Welcome to this week's edition of Smart Counsel for Lunch. I'm Leah Kofos, and I'm one of the attorneys here with the law firm of Samuel, Sayward, and Baylor in Dedham, Massachusetts. We focus our practice in the areas of estate planning, probate, elder law, and estate and trust administration. So this week, I'm going to talk to you all about hurdles. What is preventing a lot of you from creating an estate plan? Either preventing you from setting up a meeting with an attorney to talk about it, or actually, after you've had the meeting, to follow through and to actually make the decisions necessary to execute your estate plan. So all of these things, very universal reasons. So let me just tackle these one by one for you. Number one, the biggest thing, it can be scary. We all understand that thinking about these decisions where a lot of these are going to happen, a lot of the possibilities would happen either after your death or after you're incapacitated in some way. And it's really scary to think about that. This type of planning forces you to put yourself in the mindset of what you want to happen if you can't communicate that to somebody, either because you've already died or because you're incapacitated in some way. So let me put it to you this way. It's scarier not having a plan, right? Because at least right now, at least being able to communicate your decisions and communicate your wishes, you can still do that. And you can still let everybody know who you want to raise your kids, where you want your assets to go, all of those things. Every single thing in most cases with estate planning, it's usually all amendable and revocable, which means that you can change it at any point during your lifetime. Now, there are some exceptions. Irrevocable trusts, for instance, you can't really change those. There are reasons that we do that, but in the grand scheme of things, most cases, you can change everything. You can change the trustees of your trust. You can change who you name as the guardians. You can change where your money goes, who the beneficiaries are. So it's a lot scarier not having this estate plan in place versus having it in place, and being able to really put your wishes into a legal document and make sure that they're followed through. Second reason that I hear from a lot of different clients is that the decisions are just hard. Very difficult decisions. Now, I hear this most from clients who have already set up a meeting with me. They've decided that they want to go forward. They've taken that first step. But then I ask them who they want as their healthcare proxy, for instance, who they want as a guardian for their children, and they just kind of freeze. And it's understandable that that happens. It's hard coming up with those decisions and trying to think about, do I want my brother to raise my kids? What happens if they get divorced? My brother and my sister-in-law, all of these things. There are a lot of considerations that take place when you're making a seemingly easy decision. It's never that easy. So that's why we're here. That's why your lawyer is here, to be able to walk you through those. And we'll walk you through every decision you have to make, from your trustees to your guardians to where your assets go after your death and how they're used for your children, how they get to your children, how they get to your family members, all of those things. So you'll have a guide with you. You're not on your own. We don't just let you do it by yourself unless you really know who you want. But if you need help with it, it's totally fine. Everybody needs help with these sorts of things. So that kind of leads me into my next point, is that lawyers have a reputation. Lawyers have a reputation of being intimidating. I really hope that I'm not intimidating, but I know that this is a thing. It's very, very common for people to be intimidated about lawyers, about law firms, especially when we're dealing with this sort of subject matter. So I'll be the first to tell you, I work for a wonderful firm. We have a really, really great team. And the commonality with everybody who works for the firm is that everybody's really nice. Everybody's really compassionate. We want to help you make these decisions. We want you to be protected. So it's nice being able to help clients. We always think it's nice being able to help clients with topics that can be really difficult, and we know that you need this. We know that you need somebody to guide you through these decisions. And we do our best, our absolute best, to make sure that you are at ease and you're comfortable the entire process, from setting up your first meeting to the very end and signing your documents, to any updates you need with your documents years from now. We try really hard to do that. Now, the next thing I want to talk about is the money, right? It costs some money to be able to do an estate plan, and we understand that. Now, what I want you to start thinking of is the cost of a trust, for example, outweighs the cost of probate in many cases. Now, probate is what happens, and I'm sure you can look at this and hear more about this with the other videos we have and the other articles we've posted. But probate is the court process that happens if you own accounts, any assets in your individual name. It couldn't even be a house in your individual name. You don't have any beneficiaries. Maybe you just have a will. Wills still go through probate. The only really way to avoid probate is to do a trust in most cases. And the cost of doing a trust will outweigh the cost, in most cases, will outweigh the cost of actually having to go through probate and probate your assets through that court process. The other thing I want you to think about is that if it's not done right, there's a cost to litigation. So it's possible, you essentially get what you pay for. It's possible to go online and do a will, or go online and do a trust. The quality of those documents are not going to get you where you need to be, where you want to be. And in a lot of cases, doing those documents will end you up in either in probate or having your family and beneficiaries argue over these assets or argue over guardianship, things like that. And all of that, that's going to add up. So spending the money now versus spending more money later, in a lot of cases, it makes sense for our clients. And we'll talk to you about which plan is right for you. Maybe a lot of people want to start with a will first and then upgrade to a trust after they're a little bit more established. Maybe you just want to do a trust immediately. It's really up to you, and it's really, really personal to your situation that we'll be able to talk you through. Now, the last thing I want to talk about is the time that it takes. A lot of people look at this and they say, okay, I'm going to have a meeting with an attorney, probably multiple meetings. I don't have the time for that. Who has the time for that? I'm a busy person. I don't want to make that time. Now, it does take time. All right. You, at a minimum, you'll probably have 2 meetings with an attorney. You want to make sure to meet the attorney originally, hire the attorney to work with you. And during that first meeting, or maybe you'll have a second meeting where you'll talk about the specifics of your plan. So who you want to name as your guardians, who you want to name as your trustees, where you want your assets going, all of those sorts of decisions. We can either do it in the first meeting, or we can have another meeting to talk to you about that as well. But we can have a review meeting as well. The last meeting and the final meeting that you really do need, at least need the first one, and you at least need the last one, which is the signing meeting. All right. This is what happens when you sign your documents. You come into the office, you'll sign everything, and then everything's in place. So after that, you can go fund your trust, but everything else is going to be done for you. So you'll at least need a few hours spent either with an attorney or talking to an attorney, or on your own trying to figure out these decisions. Speaking with your spouse, speaking with your family members about who would be the best fit for a lot of these roles. And it does take time, but think about it as an investment in your future and an investment in this plan, because you don't want to make the wrong decisions. You don't want to go with somebody who's, kind of one and done, who's quick, who just wants you in and out, in and out. Sometimes we call those will mills. We don't want that. We want somebody who's going to be working with you and taking the time to actually make your plan work for you and be the best that it can possibly be. So that's it. Those are the hurdles that I hear most often, that we in our office hear most often, about why people have taken so long to actually do an estate plan. Now I want to leave you with this. The number one thing that I hear at the very end, at that signing meeting that I was talking about earlier, is how relieved the clients are to be done, to have signed everything, that all these roles are named and all, everything's signed, everything's good, everything's legally documented. There's just this overwhelming sense of relief for my clients. And they've told me about this often. They a lot of times think that it's going to be a worse process or a longer process than it is. But it's really not. Overall, hopefully we make things as smooth as possible for you so that you can make all these decisions and sign your documents and everything's good. And then you get to leave, you have an estate plan all set, and then you don't have to think about it again for a few more years until maybe you have a life change. Maybe there's a change in the tax law or something like that, where we'll contact you about that. Just to kind of let you know, hey, you might want to talk to your lawyer. You might want to just look at things and see if it changes anything for you. So one other thing that I'd say about the time, right? A lot of people don't have the time to do all of this or feel that they don't have the time. Like I said, it does take a while. From start to finish, I'd say that this probably takes about maybe 3 months, 3 to 4 months, somewhere in there, from the very first meeting to the signing. Now, this includes time for you to review your drafts. It includes time, obviously, for us to draft the documents and to meet with you, to have those decisions. So with that timeline, if you want to get it done before the end of the year, make an appointment now. It's almost September. It's going to be September next week, or this week, actually. So make an appointment now. At least get something on the books. Your kids are probably back in school now, so it frees up a little bit of time for you, hopefully, fingers crossed. But now's the time. If you want to get it done by the end of the year, if it was on your list to do this year at any point, just do it now. You might as well. So feel free to visit our website. You can browse through other articles that we have, other content relating to estate planning and wills and trusts and probate. And you can always watch more videos here on our YouTube channel as well. As always, feel free to hit that like and subscribe button if you want to see more of this content, hear more about any of those topics. And if you want to be notified when we post a new video, which we try to do every week. So until next time, take care. I hope to see you soon.